waiting for
Recording in progress.
Oh. If you guys can maybe go around as a small group and just let me know what your name is and also what what your business is. So we can start off with the camera girl.
My name is Tanya. I do content writing and also social media management.
Okay, great. Next, here.
I am a licensed cosmetologist with a focus on creative art and film construction.
All right.
My name is Angelica, and I do laser hair removal.
Oh, nice.
Okay.
Okay.
Yeah.
Laser hair.
Yeah.
I'm probably the artist and I'm here for 20 years. I've been doing the natural hair, and color, and I'm also trying to separate clean hair to something else.
Oh, nice. Sasha, name and then what you do. What's your business?
Oh. My name is Sasha Peters. I'm the mother to one of the youngest members that was in Brooklyn Commons. His name is Bocho. I'm his mother, his manager, his everything. I'm also a love coach, a fashion designer, and on my way to curating a journey where I can help people to capture their own personal journeys.
Nice. I love that.
I'm a multi-passionate entrepreneur. So I own a tea company called Sunset Tea Co. that I launched in the pandemic. I'm also a community relations consultant. And then I have, other things that I decided I just love to do about it. So what I do now. What do you do?
What do you like to do?
You're an dancer.
Dance in school. That's your job.
Okay. And Miss Pierre.
Oh, me, okay, my God, wait, that's so. Founder of New York Beauty Suite and the CEO of Brooklyn Common, entrepreneur, I guess, community builder, and very passionate about content building, so.
Okay, great. All right. So we have a lot of power in the room. Oh, Genesis, yes. She's sitting right behind me.
I'm launching my business by the end of the year.
Okay.
Impeccable relations, it's public relations for growing businesses.
All right, great. All right. And then for those of you who are tuning in via virtual, if you could just drop your name and what you do in the chat. All right, so moving along here, so contracts 101, key contracts you need to have. And this is not an expansive list because I know we only have a certain amount of time. This is just to touch on some of the important ones. So first is a legal disclaimer, just letting you guys know this presentation and any visual aids or handouts that have been prepared by our Pierre Legal LLC. They have been gathered from sources generally considered to be reliable. Any information given is intended to provide basic and general information and is not legal advice. None of the our Pierre Legal LLC owners, employees, contractors, or partners makes any representation or warranty to or assumes any responsibility for the accuracy or completeness of the presentation materials. By attending this presentation, you agree to hold harmless and release from any liability whatsoever and not to pursue any claim or cause of action against our Pierre Legal LLC. Person in connection with the presentation materials, or the speakers, you agree to perform your own due diligence. Nothing in this presentation is legal advice. You should talk to a lawyer. Each person here has unique experiences or circumstances that will affect the advice that should be given. I am a lawyer, but I always give the disclaimer because sometimes people hear things and they act on it. They're like, well, I went to this presentation and this attorney said, exactly this. Well, I'm not your lawyer. So, all right, moving along. Okay, so what is a contract? So a contract is either a written or spoken agreement between two or more parties that include terms and conditions, which creates a legal obligation. The terms of a contract are enforceable by law with clearly defined penalties and remedies should the contract be breached. A breach of contract is a failure without legal excuse to perform any part of the contract. So I know that sometimes people, one of my colleagues likes to call them like locker room lawyers. So, somebody will say, that's not a contract because it's not written down. Or somebody will say, well, this is a contract because, it's X, Y, and Z. But a lot of times people don't really understand like what exactly a contract is. So it's always good to go to the definition to have an understanding of not only what is a contract, but like how can a contract, like what's included in a contract. It's clearly defined penalties and remedies. It basically lets you know like what are the parameters of this agreement between you and this other person, right? So, let's see what is this? Okay, what is required to make a valid contract? So, everything has recipes, everything has pieces, right? So, this is my favorite Diddy thing here. So offer, acceptance, consideration. Those are the three main components of a contract. This is what you learn, like if law school 101, they start off by saying offer, acceptance, consideration. But it's a little bit more than that, right? There's actually several other pieces. So I would say total of 6 things that actually form a contract. But offer, acceptance, and consideration are essentially like the foundation of a contract, right? So offer is a promise by one party to another that they will or will not perform a specific action in the future, right?
Yep. Give me a second.
No problem.
Can everyone hear in Sarah's?
Yes, now I can see.
Yeah, I don't see the presentation, Genesis.
Do you see it now?
No, I just see the logo.
Just the logo, yeah.
Why does that keep happening?
Oh, it's on. Oh, I don't know. Hmm.
Can everyone hear and see?
Okay.
Yes,
No, no
yes.
Okay, great. So we went on by saying that there are 6 essential elements, although offer, acceptance, and consideration are the foundations of a contract. And offer, a promise by one party to another that they will or will not perform a specific action in the future. So an example, I will pay you $2,000 to purchase my vehicle, right? That's an offer. I'm offering you something, right? Acceptance is essentially a mirror of the terms of an offer. So basically you would accept and say, I accept to purchase your vehicle for $2,000. There we have offer and acceptance. I don't know the password, I'm sorry. Genesis. It keeps okay. So you see how there's an offer and acceptance. I make an offer to you, you accept it, that's offer and acceptance. Consideration, for whatever reason, has people confused. Like, what exactly does it mean to have consideration? Is it just money? Is money consideration? We saw Diddy was flying money all over the place, but consideration is not necessarily money. It could be anything of value, right? So instead of, paying Tanya $2,000, I can say I have an e-bike that's worth, $1,500, and I have a watch that's $500. I will give you those in exchange for. So that there can be consideration. So it's not always money. It can be an exchange of other goods, and it can even be an exchange of other services. That could be the consideration. It just has to be something of value, right? All right. Okay. All right. So after that, you have to have capacity, right? A lot of times people, they don't think about these things, but if I'm entering into a contract with Angelica, I need to be of sound mind, right? Because guess what? If I am not of sound mind, meaning if I have some sort of dementia, if I have any temporary lapse of capacity, any temporary lapse of capacity, at that point, guess what? There's no contract between me and Angelica. If I signed that agreement and I was going through some sort of bout of, like I said, dementia or something else that would cause me to not be of sound mind, sometimes extreme intoxication, somebody being so high that they're so out of their mind, entering into an agreement, at that point, there is no agreement, right? Well, that's where you end up going forward into the law. Now you have to, there's investigations that have to take place to now determine whether or not this individual had capacity or not had capacity. So, but generally, like, I would say rule of thumb, if you're both drinking, don't enter into an agreement, right? Don't enter into an agreement. So you have to have capacity and legality, right? So every state governs contracts, right? There are some contracts that are universal, like if I sign it here, it could be, effective in California. But state laws are state laws. California has its laws, New York has its laws. So you have to also really take into consideration the jurisdiction, the state in which you are also, putting this contract together or hoping that this contract is enforceable, right? Because I can draft a contract here in New York and it's fine in New York, but it's not enforceable in California, right? So you have to be mindful as well too. And I know that, there's certain industries where, this is a thing, and there are other industries where it might not matter, but you just want to make sure that, okay, I'm entering into this agreement. I need to make sure that this particular agreement is going to stand wherever it is I need it to stand, right?
Are terms and conditions considered contract as well?
Well, those are terms and conditions are terms and conditions considered contracts as well? That was the question. Those are terms and conditions are contained within the contract, right? Okay, so these are 5 types of business contracts. Again, there's a bunch more, but these are some of the main ones: non-disclosure agreement, partnership agreements, licensing agreements, employment contracts, and contractor agreements. So let's talk about the non-disclosure agreement. So what is a non-disclosure agreement, right? A non-disclosure agreement is an agreement that is legally binding, and it establishes a confidential relationship. So for example, we have, Tanya's business, and we have Karen's business, Karen's business. So let's say these 2 individuals come together and they're like, oh, we want to potentially get into business together. We want to talk about some joint ventures, right? But Tanya might have some confidential information that she doesn't want, to be leaked out on Twitter, Black Twitter, or wherever else, people get their information. Or better yet, Tanya has a competitor that's like in the suite next door, and she doesn't want that information to get to the hands of the competitor because, who wants that, right? So, and maybe maybe Tanya understands that, Karen, although she's, a lovely individual, but I don't know Karen like that. I'm just trying to get this paper with her, but I don't really know her like that. And so you want to be able to protect some of the confidential information that may or may not be divulged during your conversations. And so that's why a non-disclosure is important, because it keeps that information confidential, but then also brings about some sort of consequence for an individual who breaches that agreement, right?
So the consequences is something that's agreed upon too?
Well, the consequences can be agreed upon, right? Or at least, let me not say agreed upon, it could be contained into the NDA, and if the other person signs it, then they are then consenting to that, right? And so the NDA could also be called a confidentiality agreement. So not everybody goes around calling it NDAs or non-disclosures. It could be it could be called a confidentiality agreement as well. So these agreements, they're very common in businesses because, again, for the examples that I gave you, sometimes, like maybe I might not have anything confidential in my business, so I don't really care. I could meet with you and say, let's get this done. I have no secrets here, but that's not always the case, right? Especially when we're talking about pre-development, when we're in the stages, especially for those of you who might be creating, like, I know Sunset Tico, there may be some secret formulas, right? That you might be thinking about putting together. You don't want that information out. To the public, especially, if you're in those stages of creating. So that's where you see non-disclosure agreements as well too. Now, so here they allow the parties to share. So when you have the non-disclosure agreement, it allows the parties to share sensitive information with each other without the fear that it's going to get into the wrong hands, right? And so in this case, you might hear it also called as a mutual non-disclosure agreement, where both of you are agreeing that we will not share each other's information, not just because sometimes there's one-sided non-disclosure, where Angelica, I might ask Angelica to not disclose any information, but I am not giving that same, agreement to her. So there are one-sided non-disclosure agreements, and then there are mutual. So you want to be careful when you are presented with a non-disclosure agreement that it's what you think in your mind, that just because you see it like, oh, non-disclosure, I know what this is. There's one-sided and then there's mutual. They're not always, it's not always both sides. So you can be signing an agreement that says you will keep your mouth shut, but it doesn't necessarily keep the other person from keeping their mouth shut, right? Okay. So the key takeaways, it acknowledges a confidential relationship. It's usually used in business discussions about potential ventures. If you guys have employees, sometimes non-disclosure agreements are part of the employment contract packet, because again, I'm going to keep using you as an example. Sunset has, tea recipes, and she may have employees that are going to be working under her. And she wants to make sure that these employees now, don't go off to the next tea company and say, let me tell you, I have some stuff for you if you hire me and give me X amount of money. That's how a lot of these things happen, right? With these big organizations, they have non-disclosure agreements for their employees because Google doesn't want their employee going to, I don't know, Salesforce or one of these other companies and sharing like, in-depth secret information. So you want to make sure that even with your employees, if you're in that business where you have that sensitive information, that you get them to sign a non-disclosure agreement. And I would even go as far as, I always say interns as well too, volunteers, depending, because I don't know what capacity you'll have these individuals in, but anyone that is going to be dealing with sensitive information that you don't want them to share, I would have them sign the NDA, because sometimes people see volunteers and interns as like, oh, they're just, one day, it's not that serious. It can be serious, depending on what your business is.
We have a question.
Okay.
Patricia, when a contract is signed for, say, photography services, does it suffice to have a confidentiality agreement in the service agreement?
In terms
Clause.
with, or just a clause? Yeah, you can have a clause.
Yes, you can have a clause, Patricia.
You just have to make sure that the language of the clause, again, protects you in the way that you need to be protected. And so here are just some pros and cons of the NDA, because sometimes people are like, somebody came to me with, with an idea, somebody came to me with a business venture and I presented them with the NDA and now they're looking at me sideways. Or now they're just like, ooh, I feel funny about you presenting me this NDA. Well, that can happen, right? Because when you're presenting somebody an NDA, the idea is that you don't trust me. You don't trust me, you're not, comfortable. It does create like this really weird, tense atmosphere. It could prevent people from, depending on how large your organization is, it could prevent people from joining because they're like, I don't want to be bound by any type of like confidentiality clauses. But at the end of the day, you know your business, right? And I mean, all of these major organizations and companies, they have NDAs. If you really want to be a part of this, you have to understand, right? And so although it can create this atmosphere of mistrust, I think that for the most part, when it comes to your business, if you have information that you need to keep confidential, you need to do what's best. And maybe that individual is just not the person to work with, because ideally I would understand, right? If you are a tea company, I keep coming back to the tea company because I know they have like the trade secrets. I'm going to a tea company that's going to have recipes, that's going to have, products, that's going to have ingredients, and I'm going to do business with you. I'm going to be in the know and privy to some of this secret information. I should understand, if you give me an NDA, why that is, right? So that's just some of the cons. Some people, I did have a client one time who presented their, potential partner with the NDA, and they were just like offended at the fact that we would even do that. But we don't know you. It's just common. It's common sense, but common sense is not common. That's what I've been hearing. So next we have the partnership agreement. All right. So the partnership agreement is a legal document that dictates how a small for-profit business or large, mid-size for-profit business will operate under two or more people. This agreement lays out the responsibilities of each partner in the business, how much of the business each partner owns, and how much the profits and losses will be split, potential scenarios that could affect the business, death of a partner, et cetera, et cetera. So it's basically like the framework for, you know, how you and this other individual or how you and this other business is going to work moving forward. And the reason that this is very important is because things happen, right? Well, let's stick here. Things happen. You don't want to get into a partnership agreement and the roadmap is not laid out. Everybody's going to have in their mind and what they believe, you know, should happen with this business. You know, it would be crazy to think that nobody would have this in mind. Like I envision this business going this way. I envision this business going that way. I envision that I'm going to get 50% of the profits and that you're going to get 50% of the profits. That's not always how it is. So you can't keep these things in your mind. You can't assume that everybody's on the same page. You know, and again, it kind of goes to the fact that when friends especially and family members are working together, there's this assumption that, oh, well, you know me, like, you know, we can do this. But no, even if you do know me, even if we're the best of friends, we should still have these things in writing because that's what's going to dictate. Because there will come a point where there's going to be a disagreement. We might be cool, but there are going to be certain things that we might not move on the same page with, right? And so situations, you know, you want to be able to have a partnership agreement that captures, you know, scenarios that might not be the case now, but if somebody dies, if I'm in partnership with 3 of you and unfortunately one of you passes away, what happens to your partnership interest? Does it automatically, you know, get split between myself and Laura? You would think so, but that doesn't have to be the case. And that's not always the case, right? Maybe your spouse wants, you know, it's like, well, I was married and it's 50-50, so therefore her interest is not my interest. Is that what the partnership wants? That now we have this spouse who now is a partner? Like, so you want to be able to outline the mechanics of your agreement in order for you to have a smooth business. I would say that a lot of businesses, partnerships that fail, it's because they don't have a clear roadmap. People don't know what the expectations are, and they don't know what, you know, not just the expectations, but they really just have no idea of how things are supposed to like move. And so you need the partnership agreement to be able to outline that for you. That's going to make life easier. It's going to reduce the conflicts. There's going to be conflicts, but again, you have the roadmap, everybody agreed to it. If worse comes to worse, you take them to court, you know, it's an enforceable document, and you move on from there. So next we have the employment contract. So again, you know, I live in the world of labor and employment, so I deal with employment contracts all the time. And it's interesting that most people don't have employment contracts in place when they have employees. Even if you have one employee, you want to have an employment contract. So an employment contract is an agreement between an employer and an employee regarding the employee's term of employment. It can be implied, oral, or written, involving a lengthy physical contract that the employee signs. The terms laid out in the contract depend on what was agreed upon when the employee confirmed that they would take the position. So with these employee contracts, you want to make sure that they're very clear. A lot, and I think that the overarching or the overarching theme is you want clarity. Contracts are there to provide clarity. The more concise, the more clear, the more the more clear the contract is, right? The less issues you'll have. It's not that we won't have any issues, but the less issues we'll have. Most of the cases that I've had in the past when it comes to contracts is contract interpretation. Somebody interpreted this to mean this because it either was poorly drafted, it wasn't drafted properly, and you know, you, the signee, well, I interpreted it to mean this, right? So you want to make sure that your contracts are clear, and employment contracts, you want to make sure that it's clear. You want to make sure that not only you know what you're expecting of your employee, but that the employees know what's expected of them, down to the T, you know, lunch hour, like all of this. Like sometimes my contracts tend to be a little lengthy, but you want all that in there because you don't want issues. The issues arise when it's not in writing, because I know that it talks about it could be oral or implied. I always say put that thing in writing, because if it's not in writing, it didn't exist, right? Unless you have another witness, but then you might question if that person is biased. We don't have time for all this, right? So we want to make sure that our contracts are clear. So now the advantages of employment contracts, again, clearly defined duties and benefits. The employment contract defines responsibilities for the job, and you get into the nitty-gritty with it. And even in terms of, expectations of, okay, my employer said, I had a situation where one of my employers were like, okay, we're gonna give you a 15% bonus at the end of the year if you're able to do X, Y, and Z. I went back to my employment contract, I'm like, well, it's not in there. And they're like, no, but it's understood. No, it's not understood. I need you to send me an email that says that this is what it is as an addendum to my employment contract, because guess what? If she unfortunately gets hit by a bus, if something happens, right? Not to be so grim, but we live in New York City, these things happen all the time. If she's not here, I'm not gonna tell the next person, yeah, the lady before, you said that I get this. It's not in writing, right? So they can't honor it. So I always think about, what if the people who are coming together to make this contract, something happens, either they lose capacity or whatever it is. How will this contract stand? How will this agreement stand? You put it in writing. You make sure you put it in writing. This oral stuff, everybody's telling you it's okay if it's oral, you put it in writing. Even if it's a text message, following up, put in a text message. Yes.
For a smaller company, is it possible, or do you recommend, depending on everyone's skills in the team, to have specifically tailored contracts for every worker or associate?
I think it would depend on what they're doing, right? Because, you may have an employee that is only dealing with confidential information, so their agreement may look a little different from somebody who's like, the porter, who's, the cleaner, or whatever the case is. So it really depends on what these roles are to determine whether or not you need a more detailed agreement for that individual. Okay, so next we have, being mindful of the time, so website terms of use. Okay, so these are contracts between the website owner and the purchaser or service users via the website. So anybody who's been on a website, you guys have seen, websites, this terms of use, and we just keep clicking. We just keep clicking because we just want to get to what we want to get. Nobody's reading that 1 to 2 page document, right? But now if you are a business owner and you are operating in the interwebs, as I like to call them, you want to make sure that you have your website terms of use. And so what is it? It is an agreement that a user must follow and abide, what you're prescribing in order for them to use your website, right? In order for them to get on, right? So the terms of use can go by many other names. Some people call them terms of services, terms and conditions. Terms of use are often seen in the e-commerce websites and social media websites. That's mostly where you're going to see these types of agreements, but it's not necessarily limited to that. And so a term of use that is legitimate is a legally binding agreement. So when you're clicking, you're agreeing to whatever it is that they're saying. So just, keep that in mind. So as business owners, you want to make sure that when you're putting together your terms of use, that you are tailoring it also to your business as well too. I know there's a lot of general templates out there. People just want to copy and paste, like, oh, okay, terms of use, let me just copy and paste it and put it on my website. Wouldn't do that. I mean, for the most part, it is standard language. It is standard language, but depending on what your business is, you may want to tailor it, because again, this terms of use is being used for many reasons. It's being used to shield you from potential liability, right? Somebody gets on your website, something happens, they want to come after you, and you have nothing to protect you because you don't have a terms of use. So you want to be able to mitigate the liability on your website. People are always looking for somebody to blame when something happens, right? And even if you really had nothing to do with nothing, but they're like, but I went on that website, right? And this is what happened. They could come after you, right? You can determine the permitted conduct on your website. So you can dictate what type of content, what type of conduct you want happening on your website. Because some people, depending on the industry that they're in, it could be, they might be running a blog post, right? They might be running some sort of forum. So it's not just, I have services I'm selling, here are my terms and services. Some people do have open forums and stuff. So you want to be able to monitor, like, what type of language is being used? Like, what types of conversation? You don't want to be running a online platform that has a forum and people are talking about pornography. People are talking about things that are just, uncouth. You don't want that, right? So the terms of use allows you to basically manage the conduct on the website, right?
We have the terms of use on our website.
Where would you have it?
Yeah.
You can have it as a separate tab, like I think I have mine as a separate tab. Some people have it as a pop-up almost. So there are pop-ups, so there's different types of, I think there's like click wrap, there's different types of.
If it's on a tab, how would they even access it to even click on it to like complete?
Well, it depends on how you set it up. Some people, so there's one way in which you ask them to agree, click. There's another by saying that just by them accessing the website and that they are essentially, once you move forward to the next page, you've agreed to these terms, right? But some people do like this added protection of, I need you to click that you acknowledge. But it's not always necessary, right? I think it just depends on, like I know when it comes to medical professions, I've never had a website that just allowed me to move forward without clicking, I acknowledge, I understand, right? And so this piece, I don't want to get too much into it because I don't want it to go, I don't have a lot of time, but having the terms of use also allows you to incorporate an arbitration clause. So a lot of times people see like this arbitration clause and agreements and they have no idea, like, what is this arbitration clause? So basically arbitration is another forum that's not necessarily as conservative as the court system in a sense, but it allows people to kind of get together and resolve their differences without spending the amount of money and time that you would use for like court, right? So it's kind of like one step above mediation if you guys have ever been in mediation or ever like heard of what mediation is. But when you add that into your agreement, you're basically setting the tone of like how things are going to move forward. If there is a dispute, this is how we're handling it. We are going to be handling it in arbitration. We are not going to be handling it in like Supreme Court or whatever the case is. So a lot of organizations like to do that because it, in a sense, kind of, they're in a way, I guess they feel like they're able to kind of manage in a sense how these disputes are going to be handled, and also the cost that could be associated with handling these types of disputes. Oh.
Great class, thank you.
All right, so these are just 5 reasons to have terms of use. We don't have to go through all of them since we pretty much talked about them. Sales agreements are next. So sales agreements, I think for most people who are here are selling some sort of service or some sort of good, right? And so a sales agreement is a legally binding contract that clarifies the terms of a transaction, also known as a sales contract or an agreement to sell this type of document, or whatever it is. And this document is usually between 2 parties, could be between more than 2 parties, but generally between a buyer and a seller, right? The buyer is an individual organization making a purchase, while the seller is an individual organization selling the item in question. So you can use sales agreements to buy or sell either of the following: goods and services. For the most part, goods and services, a physical item related to a service such as maintenance or installation. I know that, I think, Angelica, you have a laser hair removal, that's a service that you're selling, right? And I know that Karen, you have the braid artwork. So, these are pieces that you're selling, these are goods essentially. And so when do you need a sales agreement? Well, without a sales agreement, you may not be able to protect your investment, or you may inadvertently accept liability for something out of your control. Again, the sales agreement kind of outlines this interaction of seller, between the seller and the buyer, right? Liability clauses will present in this contract. Again, it's a way to protect your investment. Let's say something happens, right? You're performing laser hair removal treatment, you know, you're moving forward with the sale. Let's say, I don't know, something takes place, the credit card doesn't go through or whatever it is. Your agreement may be able to outline, you know, steps to be able to protect you in these scenarios, right? Or let's say you are a shea butter maker, right? And so I am the buyer now. I received the shea butter maker or shea butter, but the shea butter is, it's something's off with it. Like it's, you know, maybe they didn't make it right. I don't know. They didn't cure it right. Something's wrong with it. As a buyer now, I need to be able to protect myself and get either my money back or whatever it is from the seller who sold me this defective product. Or let's say the product now injured me, right? So again, when it comes to the sales agreement, sometimes it could be very basic as just saying, you know, we're getting into business together where I'm going to sell you X amount of X, Y, and Z's, and I'm, you know, and by this particular time, you should receive them. It could be that simple, but it could also be even, you know, depending on the industry, it could even be more expansive than just, you know, a simple, I'm selling you this, I'm buying this, this is the particular time where you're going to receive it, and those types of things. So that is the sales agreement. And again, I'm kind of speeding through this because I want to make sure that I get through everything. Okay, vendor and supplier agreements. So vendor and supplier agreements, that is a contract between a vendor and a business. So a lot of you may have, you know, you have your business, but you might have a vendor that you're working with that supplies you with certain, you know, goods, right? So maybe I own a store that I sell, you know, healthcare products, but I have a vendor that supplies me CMOS, right? So this is where you'll see a lot of these types of agreements where the vendor agrees to supply specific products or services. And these agreements can be beneficial for businesses because they often provide pricing stability. The last thing you want to do is your CMOS plug. This week they come in, they're selling it to you for $15. And then next week they're like, oh, you know what? It's going to be $25 this week, right? You want to be able to create that pricing stability by having that vendor supplier agreement to govern the relationship, but also again, to provide stability, I think more importantly. So, okay, contractor agreement is next, and we're nearing the end, guys. So the contractor agreement, you know, a lot of times when people think about contractor agreement, they're like, oh, a contractor, somebody who's going to be fixing my house. Like they don't, they see it in this way where they don't really understand like what exactly this agreement is. But a contract is basically a written document that details the agreement between a client and a contractor. Contractor not necessarily being somebody who fixes homes, but a contractor can be myself, my legal services. I could be contracting my legal services out. I know we have some consultants in the room here, right? They're contracting their services. So basically it's the relationship between the client and the contractor, the person who is providing these services, right? So it reflects the services that the contractor will provide, how long the work should take, the compensation involved, and other specific like non-disclosure agreements, prohibitions against solicitation, and how disputes are to be resolved if they arise, i.e. the arbitration clause, right? So you want to make sure that you have, if you are a contractor, that you have your own contractor agreement. A lot of times people wait for other people to give them contracts. You know, you want to be able to be, I like to say, the master of your own agreement. So if you do have your own agreements, I would always say, you know, don't be hesitant to present your agreements. Don't wait for somebody else to draft up a contract for you. So if you are a contractor, make sure you have a contractor's agreement in place. If you are a client working with the contractor and this contractor did not present you with an agreement, you want to be able to say, I'm not moving forward until there is an agreement, because as a client, there are losses that you can suffer as well too, right? Let's say the contractor is supposed to deliver something within a period of time and they don't. Where's your relief if there's nothing in writing to say, this is the time frame, this is the scope of work? A lot of times we see scope of work as part of agreements. That lets everybody know what the responsibilities are and what the expectations are, right? Compensation, how much am I going to be paid? Sometimes we enter into these agreements with each other and there's no talk about how much people are getting paid, right? We want to be able to have that in writing. So other names for contractors agreements, independent contractor agreement, you guys might see that name, freelancer contracts, consultant agreements, general contractor agreements, subcontractor agreements, consulting agreements, service agreements. These are other names that people have used for contractor agreement. So we can move to the next. Okay, licensing agreement, what is that? So a licensing agreement is a written contract that gives you permission to use another party's property under a certain set of conditions. The two parties involved in this agreement are the licensor, the person allowing the permission, and the licensee, the person gaining permission. So you see this a lot of times. So in my organization, we have a lot of licensing agreements with software companies, right? They're allowing us to use their software, and so they want us to sign a licensing agreement, letting us know what they're allowing us to do, what our rights are under this agreement, et cetera, et cetera. Sometimes people license their intellectual property, which we'll get into shortly, like their, the use of their trademark. For example, you'll see that a lot of times. So if I'm in partnership with Sasha here, we're doing, I'm doing some sort of event, I can, in an event that may have some sort of like monetary, I don't know, overflow, I don't know what the word is, but I'm getting paid for something. A lot of times I might do a licensing agreement with you, Sasha, for your logo, for the right to use your logo, right? Because your logo, as we'll get into it, like that's your brand mark, right? That you don't want everybody having access to or permission to use your logo. Because if I'm having an event and I put Sasha's logo on there without any type of permission, people are gonna be like, oh, Sasha's part of this event. Sasha's endorsing this event. What if this is an event that's like, I don't know, we're killing snakes. And then there's the ASPCS, there's the PETA that are just like, snakes, like you know what I mean? Like they're outraged by it. And then now maybe you were potentially in partnership or in talks with PETA about something. And then now they're like, well, Sasha is part of this event. Sasha's logo, organization, part of this event. That's, all about killing snakes. And we're not about that. I use killing snakes because I don't want to say killing cats or dogs because I am a cat owner and we're trying to move away from this language. However, snake, I don't think I'll ever like snakes, so. But yeah, so licensing agreement, the purpose of it is really to ensure that you have legal permission to use another person's business property. And business property, a lot of times we're talking about the intellectual property, right? Their trademarks, their logos, their identifying marks. For instance, if we were to use an artist's song in a commercial, you need to sign a licensing agreement. So that's another very obvious example of a licensing agreement. Sasha sings and Sasha has this track out. I have this commercial I'm putting together. I can't just take Sasha's music and, put it into my commercial without getting the permission from Sasha, right? Because if I do that, I'm in a lot of trouble. And we've seen that play out on social media. I think even as of recently, people sampling people's songs, people getting upset about that. So that's a real life example of a licensing agreement. So think about all the different things that you could essentially, be a business's property. And so you want to start, getting into the practice of, oh, that's my girl, she sings, I'm just going to use her song right quick. No. You know what I mean? You want to ask for the permission. You want to get that licensing agreement together. And let's see here. And obviously, for various reasons, more obvious reasons, you don't want to end up in court. You don't want to end up sued, right? You don't want to end up sued over a licensing issue. Okay. All right. So we can move to the next one. Okay, so this is what a lot of you all are probably waiting for. Trademark. This is very general, I will tell you that because I knew I didn't have much time, but okay, what is a trademark? According to the US Patent and Trademark Office, or USPTO, as most people know it as, a trademark is a word, phrase, symbol, or a design that identifies your goods and services and distinguishes your brands from competitors. That's essentially the essence of a trademark, right? When you see Nike, when you see that check, you already know Nike. When you see that little, I don't know, if it's a clover, whatever, you think Adidas, whatever that Adidas thing is, right? When you see the gator with the little orange thing, people are like, oh, Florida Gators, right? There's certain marks that you see, you're like, oh, the Pepsi symbol. Even if it didn't say Pepsi, you would look at it and you're like, oh, that's Pepsi, right? So it's a mark that clearly distinguishes your brand from your competitors. You know, you don't want to, if I'm in the Pepsi making business, I'm in the cola business, I don't want, and I'm a giant in the business, I don't want another brand to have the same logo as myself, because then how will people know who's Pepsi and who's, I don't know, artichoke? It's probably artichoke flavored soda, right? But something so, but you see how it's like so vast, like, you know, vegetables, cola. If you see the mark, for the most part, people, if they see the Pepsi mark, they're gonna be like, this is Pepsi. If they see another mark that looks just like Pepsi, this causes confusion. It causes confusion, and what does that mean? It can mean a loss in revenue. If there's confusion, because let's say I'm out here buying the Pepsi 2.0 logo, I see I see the logo, and let's say it's, I don't know, it's red and not blue, but maybe red and black, but the same shape, the same space. I might think, wow, Pepsi has a new logo. I'm gonna purchase as if I'm operating as if like this is Pepsi, right? And Pepsi doesn't want that, because Pepsi doesn't want another company, you know, reaping benefits for their likeness in a sense. The only reason you're buying that is because you thought it was Pepsi. Now there's confusion, they're losing money, they don't want that, right? So the trademark is really important, especially when you're in business, because you want to be able to have that distinguishing mark. I don't want, like, let's say Karen's logo is, I don't know, a carnation flower that says like Karen in it, and then it has like some diamonds on the side or whatever the case is. And that's your logo, you've had that logo, you've trademarked it, you've established it. I now, Rita, am not gonna come out with a logo in the hair braiding business, right? The hair braiding art business that looks exactly like Karen's. Who's gonna know who's who, right? So that's why you wanna have a trademark for your business, and one obviously that is not the same as another. I get this all the time where somebody comes up with a name, right? So let's talk about the name. Ritha Pierre LLC, Ritha Pierre Legal LLC. I'm gonna trademark that name, that's my name, I'm able to do that, right? But let's say, so this is legal businesses, our Pierre Legal LLC. So let's say I wanted to trademark Apple Cider Vinegar LLC. Well, Apple Cider Vinegar LLC, we're not 100% sure what industry this is. I don't know, it could be wellness, it could be whatever, but let's say that Apple Cider Vinegar LLC, I trademark it, but let's say I'm in the business of apple cider gummies. Let's say Karen now is like, oh, I have a business, it's called Apple Cider LLC, and I want to trademark it. But it's not in apple cider vinegar gummies. It might not have anything to do with apple cider vinegar, period. It could be t-shirts, like a t-shirt line that you wanted to call apple cider vinegar. Some may argue that you technically could actually have that trademark for Apple Cider Vinegar LLC for t-shirts, because gummies and t-shirts are two separate things. So when we're talking about confusion in the consumer world, right? Will there be confusion for gummies and t-shirts, even if it's the same name? Some people might say that, right? Some people may. So the thing with the trademarks is that you want to be very, very careful when you're picking a trademark name, because you don't want to get to a point where you have to potentially change your name. And that's happened to two people that I worked with in the past, where when they came up with the name, I said, you want to change it? Because I just did a quick Google search and I saw 5 different companies. And 3 of them are in the same space that you're in. But they didn't want it because they're like, oh my gosh, this is our name. Like, I dreamt about it, God gave it to me in a dream. You know, I've already done so much work under this name. I have my Instagram page, I have this, I don't want to change it, I'm gonna move forward. They went forward, they ended up getting a cease and desist letter. Because the person who owned, let's say, XYZ Motors was like, I'm XYZ Motors, I already have a trademark for XYZ Motors. Where are you coming from with XYZ Motors? We're in the same industry. We're both in the Northeast. What are you doing, right? So now what did this individual have to do? They had to start everything from scratch, because their business was actually similar. It was similar. If it wasn't similar, maybe there was a chance that they could still move forward. But it just goes to show that there is importance. Trademarking is not just to have a cute logo. It's not just to be like, oh, I trademarked my name, girl. Like there's real ramifications. There's real consequences if you move forward with your business and you don't trademark your name or logo, right? There are a lot of consequences, and it could be the detriment of your business. Now, when it comes to registering your trademark, the federal registration is what most people, when you think about USPTO, that's what we're talking about, federal registration. That just gives you more nationwide coverage, right? So for example, Freedom Women NYC was a business I had years ago, right? And although I did trademark it, for a while, it was in the stream of commerce. Like I had my Instagram page, I was doing events under that name. It was already out there. So there was a common law recognition for Freedom Women NYC in New York. So if I never registered Freedom Women NYC in the Federal Register, I could probably be fine because I've already been out there. So if somebody tried to take my name, there would be enough, I could gather enough evidence to show that you can't, I could stop you from using this name because guess what? I have evidence out there. I've been out here in these streets with Freedom Women NYC. There's a common law claim to it, right? But it doesn't give me national protection. So if you're in Jersey and you want to do Freedom Women NYC, if I didn't trademark it with the Federal Register, you could potentially, move forward with the Freedom Women NYC, even though you're right there in Jersey. So that's kind of the difference. Because some people will say, I don't need to trademark it because I'm only working locally. It's not that serious. Possibly, but I always say, why not just file it? Why not just get the national? You don't know where your business will go, right? You started your business today, but you don't know what's going to happen in 5 years. You might be a global brand fighting for your trademark now because somebody else already bought it. The other thing to be careful of when you're moving forward in business and you have not trademarked your name or logo, there are people that are called squatters that end up, what they do is the same way they'll buy your website, they'll buy websites, they'll trademark. They do that so that they can then negotiate with you after the fact. So let's say Sasha Consulting or Sasha's Prints or whatever, right? You didn't trademark it. You're like, oh, it's been 5 years. I'm doing well. I don't need to spend that money. And Robert, who's a squatter, he's like, oh, I've been following Sasha on Instagram. I see that she does this, she does that. I'm gonna federally register a trademark Sasha Prints, right? I'm gonna also buy www.sashaprints.com because I see that she also doesn't have a website. So now something goes off in your head and you're like, I want a trademark now. Well, your trademark is already, somebody already took it, right? Somebody already applied for it. So now you can try to get it back. There's usually a negotiation process. You'll hire an attorney to try to get that trademark. But Robert might say, I want $5,000. I want $5 million, depending on how large you are. And this has happened with large organizations who did not have proper trademarks in place, where they paid out millions of dollars to somebody who just went online, paid the fee, and registered the trademark.
It's a comment. A lot of millennials are actually doing that right now, buying domains. Oh, that sounds like a great name. I know someone's gonna get it a few years from now.
Yeah, it's a thing. It's a thing. It hasn't happened to me, thank God, but I've seen it happen. It is a thing. Somebody I know, they don't do this to get other people, but they just, they're at home, they're like, ooh, www.whiterice.com. I like that. I'm just gonna buy it. And they buy these things. And then let's say you come out with a business later, years later, and you're like, why is have you guys had that happen when you're looking for your domain names and you're like, where is it?
And you're like, you can pay $30,000.
Right, it's parked, nobody's even using it, it's just parked there, right? So that happens. So what can be trademarked? Product names and nicknames, for example, both Coca-Cola and Coke are marked. Logos, sounds like the distinct NBC chime, because when you hear the NBC chime, you know it's NBC. You don't think, oh, is it Fox? You don't do that. Business names, slogans like Nike's Just Do It. When you hear Just Do It, you automatically think Nike. You don't think Adidas. Color combinations or schemes like the brown of the UPS truck, right? Certain distinct color schemes. Smells can also, people would think not, but smells can. As of recently, smells can also be trademarked.
Well, that kind of goes with fragrances.
Mhm.
So that makes sense.
So what can't be trademarked? Any mark that is already in use or is too similar to a mark already in use. So like what we talked about a little earlier. If it's already in use, you got it's not happening. Or if it's too similar to it, so you're like, okay, I'm not gonna say Sasha Prince, I'm gonna say Sasha Printful or whatever. Like, no, it's not happening. Generic descriptive words, commonly used phrases or messages. So there's a lot of, in meme culture, a lot of these like, yeah, hey girl, hey. No, hey girl, hey is not happening. You cannot trademark hey girl, hey. Direct religious quotes and passages. So you cannot trademark John 3:16 in the Bible and think that I'm gonna, like it's not happening. All right. Okay. So
How much does trademarking cost?
How much does trademarking cost? I am not sure as of today actually how much it costs, but it varies. I think the last time I did a trademark that I remembered how much it cost, it was, I think, there's different classes. So I think altogether, it gets complicated, but it was like $475 if you do like one class. And again, I don't want to get too much into it because it's like, depending on how many classes you register your product under. I mean, I did a trademark that was like, I think it was like $2,500 just for the trademark, but it's because the person had like 4 different classes. Because they wanted to register it under clothing, they wanted to register it under, I think it was like, leather, like certain, so there's certain classes when you get a little more deep into it. So each class has a fee, and then there's, if you want, there's, even with the classes, there's whether or not you want it to be, I can't remember what they call it, but either way, it varies. But it could be as low as, if they kept the price the same, maybe $475, but it could be as much as thousands and thousands and thousands of dollars if you have like 20 classes that you're trying. So like, let's say like the 200 whatever per times 30 classes or 30 whatever, you see what I'm saying? It can be cheap, but I always tell people before you think about moving forward and actually doing the trademark application, because you can do the application by yourself. You can, if you're savvy enough, you can. A lot of people have done it by themselves. The reason that a lot of times people get attorneys is because the more complex your trademarking is, you want to get an attorney for that, because you want to make sure that your trademark is under the proper class. Next thing you know, you thought that you were trademarking it for clothing, and then you ended up doing it for jewelry. So now, and then there's no like, oh, let me go back and fix it. Once you paid the money, and it is what it is. You have to redo a whole new trademarking application. There's no going back and correcting it. So you want to make sure that you're doing everything properly. But YouTube is wonderful. They have full videos on how to do it. It's just tedious, so some people just don't want to have to go through all of that. But it is possible to trademark your own. But I would always tell people just go through a lawyer, because you just want to make sure you're doing everything properly. You don't want to end up spending more money because of one little mistake that could have been caught easily by an attorney. So this is just the different trademarks explained, or the trademark symbols explained. So I don't know if you guys have seen, people will put a TM next to something that they wrote, or they'll put like an R with a circle, like they'll put, these things out there, and you're wondering like, what is this about? So these are the different trademarks symbols. So the TM, this is the most popular one you'll see. I think most of you guys have seen that. And anyone can use it regardless of your registration status. Adding the symbol lets other businesses know you have claimed a logo, a name, slogan as your own. So a lot of companies who have not actually trademarked federally, they will put the TM because there's that common law that I was talking to you about, that common law registration, right? In the sense where I've been using it, I'm putting the TM, I'm letting the world know this is mine. So that might work where I'm at locally. It might not necessarily work nationally, which is why it's important, I would say, to always just have your trademark process through USPTO. Yes. Well, sorry, I don't remember. How long does the common law kick in? So essentially, if I go on the market today and I put it out there, it's out there. right? It's out there. Now, with respect to the actual trademarking process, so let's say I I put my application through USPTO at right now, which is 12/17. I am protected from the moment the application goes through, even if it hasn't been approved yet. I have the protection, right, once it's filed. Because I know sometimes people are wondering like, oh, what's the status? Like, am I protected? If you put in the application, once you put the application through there is a protection there once you put in the application. Because sometimes trademark could take up to 2 years to be approved. I've had them approved in obviously like 6 months. I've had them approved in a year. I've had them approved, I don't know if I've had them approved in 4 months, but I know 6 months has been 6 months to a year has been generally the amount, but there's no worry. Sometimes people are worried like, oh my gosh, it's been a year, am I still protected? You're still protected.
So here are members, which is beauty and wellness entrepreneurs. Some of them who are maybe less than 2 years or less than 3, and their logos, they are still using stock images because, they just wanted to get the ball running. And then sometimes you forget like, wow, I'm decent enough established. Let me go back and cross my T's and dot my I's. How would you suggest someone to transition from that stock image to continue legitimizing the business?
Right. So with Freedom Women NYC, I never trademarked the logo. I only trademarked the name because I think I had several iterations of my logo. And I knew that that was going to be the case. So I did not want to move forward and commit to an actual logo. I trademarked the name. So individuals who are using stock images, I would always say move away from stock images, get an original design. I mean, even go to Fiverr, you can get somebody on Fiverr to create your design. But I would say that if you are an individual who has a stock image, I mean, you could always change. Like I've had like 5 different versions of the Freedom Women NYC logo. The name was trademarked. I never trademarked the logo, right? So I would say that if you're using a stock image, I would say never use stock images. Use an original design. But if you are transitioning, transition. You know what I mean? Like, if you have the stock image, get on Fiverr or find a designer. We're in the New York Beauty Suites. I know there's a lot of information sharing that's happening. Ask around. Does anybody know a graphic designer? I need a new logo. Or go, like I said, go on Fiverr and get a logo from there. Just change your logo. You know what I mean?
Then when they're ready to do that and scale that responsibility, how would you recommend them to do that research, or how to like prospect out a potential graphic designer who will do that research for them?
I mean, I'm a do-it-yourselfer. So I think that, again, it's all about asking questions, right? We're in a creative community here. Somebody knows a graphic designer. And if you don't know a graphic designer or you don't want to ask for a graphic designer, Fiverr, Fiverr? Yeah. Fiverr, yeah, that is where, when I first started, everything was Fiverr. Logo was Fiverr, graphics were Fiverr, designs, everything was Fiverr. Even copywriting was Fiverr, everything was Fiverr. And as I moved forward, I started to grow out, and then I made relationships with people within the community, and I started using people that I can see and speak to, in person, as opposed to dealing with, somebody from the internet in India or in Africa. And there's nothing wrong with that if you have a good relationship, if you have a Fiverr person that has a good relationship with, continue doing what works best for you. You don't have to move away from it because other people are saying that they have, on-site graphic designers. If Fiverr's working for you, Fiverr's working for you. But that's what I would tell somebody, it's not, sometimes we make it harder than it really is. We just need to, we go online, Google, where can I get a graphic designer? It might give you Fiverr, it might give you Upwork, it might give you all these different, all these different sites. So it's, it's taking the step, you're an entrepreneur. There, obviously you got here because you had grit and you had, you had, I don't know, fight in you in a sense. I would say, use those same skills that got you to where you are to being an entrepreneur to figure out the rest of your business, get online. I always say the internet is free for everybody and you find everything online. So yeah, so we don't need to go into the rest of this because I think everybody will be getting this presentation, but just going through the last few slides, and there's one more slide after this. So the difference between a copyright and a trademark, the reason I highlighted this is because I hear this all the time, and I try to correct people out of love. I don't do it out of being snooty, but they're just like, yeah, I'm gonna get my copyright up, and they're really talking about their trademark, and they interchange the words because they really don't know that there are different types of intellectual properties. There's copyrights, there's patents, there's trademarks, but we mostly hear about trademarks and then copyrights if you're into the writing and singing and things like that. But copyrights protect original creative works, including books, movies, songs, paintings, photos, web content, choreography, where trademark protects business and product names, slogans, and logos to help customers tell brands apart. That is the difference between a copyright and a trademark. So if I'm a poet and I'm writing my poetry book, I would want that copyrighted, right? Because I want to protect my creative works, my original works. It's not the same as trademarking. Now I can have a poetry brand for myself, right? Rita Speaks or whatever the case is, and I can get that trademark. So I can have my trademark and the copyright at the same damn time because they're not the same thing. They're all intellectual property, but they cover different things. So you're not gonna trademark your poetry to protect the creative works. You would trademark the name or the logo of the brand so that you could distinguish it, tell it apart in commerce, right? And then this is just a healthy little chart from the USPTO with respect to, trademarks, patents, or copyrights, basically breaking it down so that you guys kind of have a visual as to what that is. And then this is the question and answer section. There are questions.
So one of the questions I have is say you can trademark the logo and the name of business, so that's totally two different separate trademarks. So that's totally two different things here?
Yes.
Okay, I see why people are not getting it.
Right, it can be pretty, it can be pretty expensive. I have a friend of mine, she is a fashion designer and attorney, but when she did the process for trademarking her business, she did everything. She even thought about, I'm probably gonna sell belts as well too, so let me get it in this class. So she sat down and so it costed her several $1,000s because again, she's a designer and is in the clothing industry, but she sat down and she just trademarked everything because she's like, I don't want to come back, keep coming back. I already know that I'm going to get into belts, or I already know I'm going to get into this. Let me just do it now. But for some people, they don't have $5,000, so they'll ease into it, right? They'll do, maybe 3 classes now, and then they might go in and be like, all right, I think I want to do hats. So hats was not part of any of the other classes I did before. Let me add that on. So there's no limit in the sense of how many trademarks you can have. It's just, it's a cost thing for most people. Oh, sorry, Laura, repeat that question.
So I have 2 questions. One is when you're doing the trademarking stuff, how does that go back to like let's say you registered the business, you have the partnership and some of those agreements that you mentioned. Let's say the partnership agreement, and then let's say you trademark after you have the business agreement with a partner. How do you connect that, and do you rewrite the partnership agreement because if something were to happen, right? Who does that then?
In terms of who owns the service mark, so that's something you could incorporate into. You could always. The thing is that you could always redraft and update your agreements, right? You can always do that. I know sometimes people think that once you have it in writing, it will, right? You can always add, it's just that in the agreements, what I like to add is the clause that any type of amendments, any type of modifications, all of that needs to be approved in writing by all parties, right? So I'm not just gonna update this document and Laura's a partner and I'm like, well, this is what it is. You want to be able to make sure that in your agreement, you specify that modifications and addendums and things like that nature, updates, have to be with the consent of all of the parties that sign.
And then I had another question around businesses that have DBAs,
Mhm.
right? So that say you trademark copyright, would you suggest that you do that in for each individual DBAs? Or like once you put it out, everything that you should be covered?
I mean, you can do DBAs, but it would be what's the reason for the DBAs, right? So the thing is that I know some businesses that they have like, Pierre, LLC, whatever, that they have doing business as, I don't know, Ritha consultants or whatever the case. But I think it's like, what is the purpose for your DBA, right? What's the reason behind it? So that's something that I always say, speak to your attorneys about, your accountants about. There's a lot of things I refer people to accountants because, some attorneys, like they might be straight trademark attorneys, straight intellectual property attorneys. Other attorneys might also just do it, but there's a lot of things that your accountants, believe it or not, know with respect to business structure and formation that that's what your attorney might not know. But I go to my accountant for the most part because he deals with my business, like my money. He deals with, he knows all the tax codes, all the tax laws. And so he's sometimes a little more proficient than, maybe a business attorney that I might go to because he's actually dealing with, the muck, on a day end. So I would also say, don't be afraid to also reach out to your accountants, make sure that they're proficient. Not every accountant is a business accountant. But if you do find one that is also a business accountant, you'll be surprised to know how much they actually know about business structure and business formation, and they'll be able to assist with respect to questions like that, because it could be a situation about how are your taxes being filed, right? How are you going to move forward with your taxes with a DBA, whatever the case is.
I have a question. So, an example I'll give is Karen. So how she uses hair to make wearable pieces. Would she have to trademark all the pieces that she wants to make, or she have to trademark the use of hair to make like how?
Yeah. So for Karen, her trademark would be her name, right? And whatever the logo is, and then whatever the class is. So it's a little interesting because it is like hair, right? So for me, I would, trademark, I would pick whatever class that covers the clothing class. I might even trademark, I don't know if there's a class, pretty sure there is, but I'm not familiar. But if there's a class that includes like human hair, synthetic hair, or whatever the hair is, I would trademark under that class as well too. Because sometimes it's the materials. It could be even like the materials that you use that you might have to, because for whatever reason, the distinction or whatever the breakdown is in USPTO, that you might have to trademark something simply because of the material that's used. Like I said, I use leather earlier on, right? There's a clothing, I believe the clothing class does not include leather goods. So if I want to have like a leather bag, that's another class. That's not necessarily in the clothing class. So you want to make sure you're aware of like what all the classes are, and that you are trademarking your product in the appropriate class, right? So there is an expansive, online again has everything. All this is, searchable. It's not like a secret that only the attorneys have, but sometimes it gets overwhelming because you're just like, I don't know, like I have a shoe with a metal tip, like what does that mean, So you want to be able to go through it with the attorney to make sure that you're not missing anything. So with Karen, it could be clothing, and it could be whatever other class that might have synthetic fibers, synthetic materials, human hairs, depending, right? It could, depending on, it could.
So she'd have to trademark it in a few classes.
Right. So that's where it ends up getting more expensive, right? It could just be like, if I just want to sell t-shirts, I might be good.
And I have one more question about that. So if I trademarked, let's say, a slogan or the name of the company, would you need a different class if I wanted to put the slogan on a hat versus a t-shirt versus pants? You need a different trademark for each company.
Well, it depends. If all of those happen to fall into the clothing class, then we're good.
So
Right.
the trademark for the slogan, just having the trademark for that is not enough. You also need to trademark how you'll be using the slogan.
Circling back to terms of use.
We need to get a trademark fund.
That is very expensive.
In terms of use?
Yes, so a question is is it okay to put the website terms of use on the last tab?
You can.
Does it leave wiggle room for liability since it's at the end?
So,
I mean, I've been on websites where I don't even know where the terms of use was, but it's there somewhere, right? I think for me, I always say that it's best to have it, I mean, if you think about going to some of your favorite. Okay, if you go to some of your favorite sites, like you hop on, you know, you're like where the first page might not be the terms of use, right? It could be a tab that says terms of use. Some people like to have the pop-up, because then you're like, it's in your face, so you can't say, you know, you didn't see it. Some people, if it's not the pop-up, it's the scrolling somewhere, you know, on the page. So it really depends, but I mean, like, I've gone to many sites where when you jump on it, the first thing you see is not the terms of use, but it's there though, right? It's there.
Yeah, I stick mine in the footer.
Yeah.
Depending on, if you're like online, if you deal with like Google ads and stuff like that, they also have, they require you to add like privacy policies up for them to even like rank your page down, so like that adds a complicated layer.
Right.
I just stick it in the footer because nobody's reading it.
Right. Right, so yeah, a lot of people do put it in the footer. I think in one of my sites, it's in the footer as well too. And again, you know, it's, you just wanna make sure that it's there. It doesn't cost anything for it to be there. It's just either an extra tab or in the footer or a pop-up. And it's just really to cover yourself. We know that most people, 99% of the people are not reading terms and conditions. They are not. Even myself, like sometimes I read it if it's a company that I'm not used to, but if I'm going to H&M, I'm not looking for H&M's terms of use, you know what I mean? But it's something that you want to make sure, especially if you are selling on Shopify, any of these online platforms, that you have that there, because it definitely can protect you from potential liability. And we live in a litigious environment, right? Everybody wants to sue for everything, you know? And so we don't want to, you know, open up ourselves to that type of liability because people just want to sue. And sometimes even if you know that, oh, this is a bogus lawsuit, it's the time and the effort and potential money that you still have to defend. Like, that's the other thing that people will think about, like, oh, it's not that serious because you know what is, I know that I didn't do anything wrong anyway, so it's gonna go away. No, a lot of times people have spent hours and hours, dollars upon dollars, just on defending their position. And that's something you wanna put yourself in, you know, so. Yeah.
We had the beauty girls, when I started, they got issue with their trademark, they had to shut down. When other states, you know, they're using the exact same name.
Right.
Oh, nobody's gonna see it, and then they was like, oh my God, too much lawyer fee.
Right.
The beauty industry is dominated by that.
Right.
So that's why, hopefully, like, this information, we're gonna continue sharing it, because they're like, nobody's gonna see it, I'm in this space, and we're gonna get to see that.
But what people fail to realize, so that could have been the case maybe 10 years ago, or maybe even 5 years ago. But everything is social media, everything is viral, so you can't escape it. So what somebody in Wisconsin would never find out what was happening in New York, they are on it, you know, and especially, you know, when we're operating online, everything gets tracked into Google, right? So you type in, you just type in, you know, let's say I wanted to look up my business. Sometimes we do that. We want to see what's happening. Ritha Pierre, next thing you know, I'm like, wait, there's another Ritha Pierre LLC. Where is this? Let me find out. And that's how people are getting, you know?
3 of them, I'm for sure.
Right. Yeah.
Back in the pandemic, she started creating the masks.
Those COVID masks?
Yeah, like she was a real good designer, and I was like wearing it, but she called it two-faced lawyer, right? So she got a
letter, right? Yeah.
From what, makeup company?
Yeah.
Two-faced.
But does that work, since it's two different?
Well, it could be seen within the same industry, right? It's very close. It's too close. So yeah, so I would say, you know, anybody who, if you don't have a trademark, if you're thinking about getting your trademark, before you even talk about, let me go, you know, make this application, or even before you start your business. If you already started your business, it is what it is. Let's just hope that nobody came after you. But if you're thinking about starting your business, you know, the name is important. You could even, obviously, again, using an attorney is helpful, but there are so many like searches. You can go onto USPTO and do a trademark search. What I did, like I also went to, the New York State, Division of Corporations and see, was there any business operating in New York State with my name? Is there anything, like I did a thorough like internet search, and then after that I did like a special search, just to see is this name out there? Because if it is, I don't want anything to do with it. I don't want anybody sending me letters. I don't want to, to face the possibility of putting all this money, all this effort into this business that I already told everybody this is the name. I got products, I got labels, I have all the social media pages, I got a website built, only to have to change it. You know what I mean? And all you had to do was just step back. Because sometimes we get excited, like with that person I told you from before, they were like, and it was an amazing name, but 4 people already had it, and they're doing the same thing. Be original, think outside the box, sleep on it, pray on it, whatever you need to do, but just don't jump into it. It's like, well, this is what it is. Do your due diligence now, or else you'll pay for it later. So I think.
Do you want to end Zoom and then we can continue questions here?
Yeah, there we go. Oh, how to find me, yeah. This is how they could find me. All right. So yeah, I guess we can go ahead and end this soon. We'll do that for 2 seconds. So thank you, everyone. I'm sorry because I'm like, I had my crowd here and then I had the crowd here, so I wasn't making a lot of eye contact. But hopefully you guys found something, valuable here. Again, this is, just really one-on-one basic. Just so you guys can at least start getting the wheels turning in your heads, like, okay, this is my business. I heard there are these different contracts I might need to put in place. Let me start looking into how to get these, in place, how to start setting up these contracts. And then even thinking about, your partnerships, the business ventures, things like, trademarking, your logo, trademarking your name, just really start thinking about these things a little more seriously. Back then, people can play with business. It was like, everybody has a business, is what it is. But nowadays, like, business is serious, right? And especially if you're committed to your business and you really want to, to, even if you don't want to be a global brand, but you want your business to be taken seriously, you want to be able to take the steps to be seen as such, right? And that means putting together the contracts that will not just keep you safe, but to keep your clients safe. Because I know a lot of you guys are in the client-facing industry. But yeah, so if there are any questions that you guys might have afterwards, feel free to send me an email at Ritha, R-I-T-H-A, @rparalegal.com, and you can ask me any questions. Or if you missed that, I guess, yeah, they'll send the video and they'll send the presentation. But again, this was just really basic, general one-on-one. I do suggest that if you guys have contracts that you need to be drafted, that you seek an attorney. I know online makes you think you could do everything, but you don't want to get yourself in a position where you're using a template that doesn't protect you. You want to be able to protect yourself, and that's what contracts are supposed to do. So do it right the first time, so you don't have, so you don't suffer the consequences afterwards.
Let them know also you have the terms, the rules, that's beat up behind.
Oh yes, the New York Beauty Suite's terms and conditions, conduct, and all that stuff was drafted by myself.
That's thorough, I read that.
Like 5 pages. I told you I'm very thorough. So if you guys had to read all of that, I am the one that created that. I don't really do trademarks anymore, which is why some of the information escaped me. But as somebody who has a business and who has trademarked their own stuff, I'm familiar with it. But I do have trademark attorneys that I can refer you guys to if you are serious about trademarking your logos and your businesses and whatnot. But anything contract drafting and review, you can come to me, send me an email. And hopefully you guys got something out of it. So enjoy the rest of your day, everyone.
Thank you.
I love the way you I think now he's gonna be running. Oh, yeah.